last week we looked at the statutory definition and requirements, et cetera, of children charged in juvenile court with crimes. So today what I thought we'd do is the U.S. cases, maybe talk a little bit about the inroads that have been accomplished in the nature of, research into juveniles, research in the areas of sociology, neuropsychology, biology, et cetera, that may have had some, not that may have, that actually did have a lot of effect on some of these decisions. So we'll do the U.S. cases, and then on Thursday, we'll get into the mass cases. I may or may not end up doing student searches, but I'll let you know by then. My intent is last class, no matter what, is review for final. So depending on what we cover this week, and we'll see by Tuesday, whether, I'm sorry, by this Thursday, whether we in fact will do the student search cases or not. So I'll let you know on that. So let's take a look at some of these cases.
Like searches of student lockers and stuff? And
yes, exactly. That's on the agenda for next Tuesday currently. Not sure if we get to that or not. So why did I include Galt, which you guys read in first class almost?
As a review of the due process rights that might be juveniles.
So Mike says as a review. What's another reason?
Was it right to counsel?
Yeah, those are the rights that Mike is alluding to, I think. But what's the reason why? I mean, obviously you read it once, you should know it or know it by the time of the final. So why am I making you read it again? That's kind of odd, isn't it?
Well, they all tie, it ties into all these other cases.
How does it tie in?
Because it started all of this.
It started all of this. How?
Because before Gall,
Go ahead, you get into it.
Before Gall, they didn't have any, the juveniles didn't have any of these rights.
Why not? Why not? Jonathan?
Case of first impression?
Well, it was at the time, sure. The Supreme Court decided it, yeah. Laura has her hand up too.
Because it's a civil adjudication rather than criminal?
I'm not sure if you're answering the question, though, that Mike is sort of going there. Why are we reading it again?
Well, before Galt, they didn't have the due process rights because the juveniles, it was being held as a civil proceeding rather than a criminal proceeding. So they didn't.
The reason for juvenile?
Well, they were treated as the same, and you had kids that were being, murdered, put to death and for crimes, and
so the reason for a separate juvenile system was?
to recognize that juveniles haven't reached the mental abilities of being able to reason and understand, even if they knew right from wrong, they didn't fully understand the implications of their actions, and essentially it's sort of a disability. I mean, it's the same thing as someone who's mentally unstable. They may know that it's wrong, but can't rationalize, how their behavior should be different or what the impact of their actions are on other people. And so it was set up to treat minors as not fully developed.
And what would the separate system accomplish, Joe?
Well,
So Mike is giving us the reasons why.
from what I gather from the cases, having a separate system allows the children to still have a chance.
To what?
To pretty much still have a chance to rehabilitate themselves, essentially.
Rehabilitation, okay. Stephanie, is that what you were going to say?
Yeah, I was going to say that there's a difference between the adults, which is basically for punishment, and the courts now look at the children as still growing, still learning, and there's a possibility of a turnaround in the future. So they focus in on treatment and rehabilitation as opposed to just sentencing and punishing.
Is the side to my right the state, by the way? I think I said we were gonna switch.
Switch.
We swap
The state. Yeah, we are the state.
And the side to my left, juvenile. So, to the state, how does the doctrine of parens patriae play into what we're discussing here? Remember that term, parens patriae?
Well, it affords the state the ability to step in and provide guardianship and care for youth that are in need of it, that aren't getting proper care from their parents or.
John, I forgot what side you're in. Where's the cutoff?
Me.
Okay, so John, now I forgot the question I was going to ask you. Wait a minute. So, getting back to the why does the state have these obligations or duties or responsibilities to children?
I think one of the cases talks about proportionality of the punishment and like how if a 15-year-old gets a life sentence versus a 75-year-old, it's a.
So how do you, we'll get to that, but how do you tie something like that into the doctrine of parens patriae?
I'm not sure what that is. I didn't find it in my notes.
Okay. Anybody have thoughts? We'll come to this as we discuss these cases. It should be a little bit of a review, Laura.
You step into the role of parent, so you're supposed to guide.
So why does the state step into the role of a parent? Why should the state step into the role of a parent? And Laura, I can't tell if you're looking at me.
I'm looking.
Laura,
I can't see you.
Laura's eyes are dilated, so she's wearing sunglasses. Were you going to continue? Oh. Why should the state step into the role of a parent? Amanda?
To protect the safety of the child or their welfare, well-being.
Yeah, child welfare, right? It's the duty and the older cases that we read, the Prince v. Mass, et cetera, the duty and responsibility of the state to intervene, not just in abuse and neglect cases like the cases that we have looked at in the past month or so, but also in cases like this as well. And remember, I pointed out the purpose clause of actually our delinquency statute in Massachusetts, 1953, talks about that purpose as well, that these are children in need of aid, encouragement, and guidance. And it's actually the Commonwealth's responsibility relative to that's one a purpose of these delinquency proceedings, even though they're I don't want to say that they're criminal proceedings, no, but even though they're proceedings where the child allegedly has committed a crime. So anyway, we don't really have to revisit Galt in the sense that we're going to go through and brief it again. But Amanda, you started to list the important rights that came out of Galt, so I'm going to come back to you.
Okay.
It was what? You said notice?
I think it was right to notice, right to counsel. I think your amendment rights, Fifth Amendment rights, 14th Amendment.
No, wait. Notice right to counsel. This is a child in an adjudicatory proceeding similar to an adult proceeding. So, yeah, you got it.
The confrontation, self-incrimination, cross-examination.
You got it.
Was it
It's only four. There's only four.
Only four? Okay.
Remember, he made other arguments, but you notice your right to counsel, your confrontation, which is the Fifth Amendment, and your right to cross-examination. And your privilege against self-examination. But appellate review is a statutory right in Massachusetts. So all of these cases can and should, when there are errors, get appealed. And if you remember, another reason why I had you read the Galt opinion again, it is one of the cases that I've included in the pack, that I actually included the dissent. Even though it's a Supreme Court case, that's, the law of the land, the dissent isn't part really of the opinion that's binding on the states. Go back and read the dissent again, because the tension that we've been talking about, the tension between the original, parents patriae philosophy of the court, that you need a separate system, and you can't treat kids like adults, they're different, etc. Versus now what we're looking at in terms of these Supreme Court cases, versus due process rights like adults. The dissent talks about going sort of backwards into time. Mike said, you said before, that they got hanged, they were killed, etc., just like adults did. And if you remember back then when we read Galt, I don't know if I have it here, I actually read you a quote from the dissent, if I can find it. Yes, okay. Justice Stewart predicted in Galt, and I want you to think about this, that this trend sort of away from rehabilitation and protection towards affording juveniles more adult-like rights. He predicted this trend might end up backfiring, and I'm going to read you a kind of a lengthy quote, but I need to read it so you guys can think about this. He said, the inflexible restrictions that, and I don't know what page it was on. Oh yeah, no I don't, I'm sorry. The inflexible restrictions that the Constitution so wisely made applicable to adversary criminal trials have no place, he said, have no inevitable place in the proceedings of those public social agencies known as juvenile or family courts. He continues, and to impose the court's long catalog of requirements upon juvenile proceedings, all those due process rights that Amanda just listed for us, in every area of the country is to invite a long step backwards into the 19th century. In that era, there were no juvenile proceedings, and a child was tried in a conventional criminal court with all the trappings of a conventional criminal trial. So it was that a 12-year-old boy named James Guild was tried in New Jersey for killing Catherine Beeks. A jury found him guilty of murder, now this is before juvenile court, right? And he was sentenced to death by hanging. The sentence was executed. It was all very constitutional. It was all very constitutional. What does that mean? What's he telling us, Stephanie?
It didn't violate the rights.
It didn't violate his rights. He got the same rights as an adult. He was treated like an adult for purpose of the trial, had all of his due process rights, and the same punishment as an adult. So he was worried back then with Galt in the early 70s that you begin to, afford more and more adult-like due process rights, making these proceedings more adversarial, and you might arrive at a point in time when there's no need for a juvenile court, that you're doing all the same stuff that you would be doing in an adult court anyway. Something to think about and ponder as we move on with the MacGyver case. I think was the first actual case that you're reading for the first time in this pack of cases. And that was decided around the same time. So remember, all these cases that were decided in the late 60s, early 70s, were cases where the Supreme Court recognized that children in juvenile proceedings now should get, rights similar to adults. Somebody tell us about MacGyver. Let's see, Cole or Amanda? Cole, Amanda. Amanda, all right.
So MacGyver was 16 years old and was charged with robbery, larceny, and receiving stolen goods, acts of juvenile delinquency at the time. The issue in this case is whether the due process clause of the 14th Amendment assures the right of trial by jury to a juvenile delinquency proceeding. This case kind of confused me a little bit. I wasn't really sure if like the time period that it was in, or, because then it started going into Edward Terry, and I wasn't really sure if they
So what you
did-
just told us what the issue was?
Yep.
Which I repeated again for me, please?
Whether the due process clause of the 14th Amendment
Yep.
assures the right to trial by jury in any
In an adjudicatory.
adjudicatory phase of state juvenile court delinquency proceeding.
Because remember, Galt also mentions the adjudicatory phase. Later on, not actually before Galt, and you have that case in your pack as well, but the Kent case also dealt with the old, transfer of position. So that was not the adjudicatory phase, but a different phase of juvenile proceedings. So how does the court answer that question? Do you need a jury trial, under the federal standard?
No,
No.
but I'm just trying to find where I highlighted that exactly. Even though it's granted by the Sixth Amendment.
So
Let me see.
let's go through the court's rationale for that. After I just gave you guys the dissent's rationale in Galt, which was a similar rationale, right, Jonathan?
Along the lines of what you said, they said that, that most likely if they gave them a right to a jury trial, it would make it more adversarial, and then it would be more like an adult proceeding, so there wouldn't be a need for it.
So there's three reasons almost, or two reasons that you just gave us. More adversarial, more like an adult proceedings, two reasons for the state. How about you guys that represent juveniles? Give us a reason for actually affording jury trials to juveniles, again, in the adjudicatory phase of a juvenile proceeding.
So that they could be judged by their peers.
So they could be judged by who? The community, come back to the reason that it's fair, fundamental constitution for someone to have a jury trial.
So that
Where does the jury trial right come from?
that's fair and equitable.
Nicole?
I think the Sixth Amendment.
If you're arguing that, say you were the appellant in this case, and obviously I pointed it out in our state statute as well, so we already know that Massachusetts grants jury trials, right? Statutorily, under Chapter 119, kids have the right to jury trial, even though the feds, MacGyver v. Pennsylvania, holds that it's not a federal constitutional right. So it's one instance where, again, Massachusetts is affording more rights to defendants. But I want you to think about the reason why. So what would be a reason why?
Reason why we don't give them?
No, why we do in Massachusetts. Laura?
Impartiality of the jury.
I don't know what you mean by that. Juries are supposed to be invited. What is the reason for a jury trial in the first place? You're describing what a jury do. Does that come back to the reason why a juvenile should have one? Where, again, I've heard from the state side saying the reason why a juvenile shouldn't have one is you're gonna make the proceedings more adversarial. And you're gonna make them more like adult proceedings, and this is juvenile court after all.
The
Right.
dissent lays out pretty good. The dissent, the opinion lays out pretty good.
In the MacGyver opinion. So you look at, did I give you the dissent in MacGyver?
Yeah.
I did, okay. Even if you don't have it in front of you, think in terms of kids' rights and why they should have a right that is an identical right that's afforded adults in adult court, adult charged with crime, charged with crime, you're in adult court, juvenile charged with crime, juvenile court, let's just think about juvenile court for now, not confused with transfer hearings and whatnot. So what is the reason why a juvenile should have say?
Potential loss of liberty.
Loss of liberty? Okay, so expound on that, what does that mean? Because that's the Galt rationale, right?
Right. So, I mean, you could end up in jail or detention center, DYS, you know, lose your liberty.
Okay, so liberty is one. Nicole, do you want to add to that or say something different?
Well, in an adult case, if you are charged with a crime or whatever that stays on your record, isn't there a way for juveniles where, depending on what it is, it disappears from the record, or it's not seen as quite so important to have a juvenile record than it is to have an adult record for jobs and things like that?
Wait, are you arguing for the juvenile, or you just
The
confused me?
well, I'm trying to argue for the juvenile, but I would say that the children, if they had a right to a jury trial, they didn't, I don't know. She said loss of liberty, so what I'm thinking is their record. You know, if they had a jury trial, they had a fair chance to, you know, say yes, they're innocent, no, they're guilty, or whatever they're gonna say. Couldn't a jury be a little bit more understanding? It's the record of the child, it stays with them forever. Whereas
Think of it this way as well. It's a choice, right, the defendant makes. And the defendant, when the defendant makes that choice, the judge also has to be sure that the defendant has voluntarily waived that choice. But it's a choice that's afforded, again, matter of fact, to adult criminal defendants, as this is your right to jury trial. Where the Supreme Court has spoken that in MacGyver, which is still the standard federally, that you don't need something like this for juveniles, because you're gonna make the proceeding adversarial, as Jonathan said, and you're gonna sort of change the reason for the separateness of juvenile proceedings. You're gonna make them too adult-like, and you don't need this. That you have juvenile court judges that, you know, that are specialists, that know about the best interest of children, and that they can make the decisions, and that therefore you don't need the jury. That would be right. That's, I'm giving you guys your reasons, expounding more than what Jonathan has said. But we know that Massachusetts did go further than that. So what would have been the rationale of the legislature in writing into 119? Because the legislature didn't have to do that. The juvenile court judges could make, could do, certainly have the expertise to handle the trials. So why do we have a right to trial by jury in Massachusetts? I guess the bottom line is that's what I'm asking. Laura?
So the child would feel like he was dealt with fairly? And they said it wasn't more traumatic, that having a trial by jury wasn't more traumatic than everything he had already gone through.
Mm-hmm. So you're looking at some of the dissent, right? MacGyver, good.
Yeah,
Okay.
and it's not secret as it is, because one of the claims was to keep the proceedings secret, but it's not secret anyway, because you already have the judge, the attorneys, the witnesses, the probation officers.
Okay.
Amanda had already mentioned the peers.
Mm-hmm.
And they spoke about it, that even though we call it a civil procedure, it's not really murder's murder, robbery's robbery. But it's
You
not-
said fairness. Where have you heard that term before? I mean, it's really a general term, but it has been used quite frequently when talking about juvenile cases and juvenile standards. And actually, it's preceded by the word fundamental. You've heard fundamental fairness before. And I think that's what you were getting at, Laura.
Yeah.
When you said it's just makes the proceedings, in terms of the general fundamentals, fairness standards of juvenile proceedings, that, you need to at least offer the choice to juveniles.
That came from golf.
What's that?
Didn't fundamental fairness come from golf?
Good, good. Joe, did you want to add to that, or
Well, yeah,
say
so-
from the state side again?
No, I just want to add, that it mentions that the framers, had never intended to place power in one official,
Good.
and
Yeah. Mhm.
that,
Mhm.
and to take away the protection of the law, from the rights of an individual. So, they were talking about how, a juvenile might be prejudiced against if a judge could have potentially read something about him, like a police report or something beforehand,
Okay.
and therefore that power would lie solely in a judge if the option for jury trial wasn't available, and that judge could be prejudiced, and therefore the child would be losing out on the rights to a fair trial.
Okay.
Right, the juvenile might have also come before the judge 2 or 3 times.
Many times. I know you. You are again. And the juvenile is like, oh, damn, it's him or her again. Why can't I have a jury the same way the adults do? This isn't fair. Absolutely. Oh, except for him. I was doing this with him. That's all it is. I should, MacGyver, you really don't even need to know the facts of MacGyver. We just know that the federal rule is no jury trial. Massachusetts, again, happens to be one of those states that, in our case, it's by the legislature, not by an SJC opinion, that's affording the right to trial by jury. What about Shelby Martin? So MacGyver's jury trial, what's Shelby Martin about?
Preventers of detention.
Yeah, pre-trial detention. Joe, you want to talk about that case?
Sure. The issue here is whether preventive detention of juveniles pursuant to the statute is compatible with fundamental fairness that we were talking about before.
What were they doing to the kids in New York back then? And what was the argument
They were-
for the kids?
Well, they were, on the state, so.
No, you
Oh.
just factually,
Oh, okay.
yeah, rather than an argument, yeah.
Okay, well, no, they were detaining them.
At what point in the trial process?
It was before the probable cause hearing, so they were being, pending fact finding hearings, they were being detained before those.
Yeah, different from bail, right?
Right. I don't think they could be bailed out.
Then think about it this way, so would this procedure be constitutional for an adult?
No.
Jim is saying no, because, and you'd be making the same sort of argument for the child, so I'll look to you to make the argument.
The individual has a right to, obviously, if they're innocent or proven guilty, so they have a right to bail and not to be held unless there's some mitigating unless there's some circumstance, certainly like a safety issue, something that would cause the court or the judge to believe that if he allows the adult out or the juvenile, that the juvenile, the adult would further their criminal activity on a safety issue, like a murder or something like that. But in most cases, the
Right.
adult can't hold somebody without possibility of bail. Bail may be set at a higher rate depending on the severity of the crime. But
Correct.
you just can't throw them in jail without a trial.
So what's the state's argument then, that preventive detention like this is okay for juveniles when it's not okay for adults, Jonathan?
I was gonna go the other way.
Oh.
Well, I can answer that question.
Okay.
But I was gonna say that the probability of erroneous deprivation, like if you hold the child before even having a fact finding, hearing, then the probability of the erroneous deprivation is high in that case. So it wouldn't be constitutional for a bill. But
The judge, arguing with the state.
spoke about, I don't remember what the actual standard was, but it was, for one of the defendants, they were found, or they were arrested at 11 at night. He lied about who he lived with, and the court made the determination that with that, there was a high probability that he would engage in delinquent activity up until the point that he was actually tried. So that was the reasoning behind holding him. It was in his best interest so that he doesn't continue down that path.
Okay, so you're saying one of the reasons, or maybe, I don't know if you're saying it's the major reason why preventive detention for juveniles is okay, is because of the best interest of the child.
Right, they talk about the best interest of the child that he doesn't continue, and also they spoke about the community as well, so that he's not, endangering the community if he goes down that road.
So protecting both the juvenile and the public as well, is what you're saying. Okay, John?
Yeah, no, just it specifically mentioned here that, the juveniles are considered to be under the control of their parents, and if that control falters, which, we believe it has here, then the state takes on the role of parents patriarch, and like Jonathan said, it's the best interest of not only the child, but the community.
Okay. So now we just read two cases that were more connected to the state's role in protecting children and rehabilitation, and the fact that juvenile proceedings should be different from adults. Now we get to Winship and some of these other cases where the Supreme Court vacillates the other way, right? Winship, Nicole?
Okay. Samuel Winship, he was 12 years old. He was arrested for stealing a woman's $112 from her pocketbook in her locker. The charge also stated in the case that it would have been larceny had it been done by an adult. The main question was whether his guilt should be proven by preponderance of the evidence or beyond a reasonable doubt. And the court ruled that preponderance of the evidence is all that they really need in order to prove, right? Am I wrong? Okay, nope, let me change it, beyond a reasonable doubt, because it's strict.
Online people should have been hearing shouts by the other students, saying, why, wait a minute.
Yeah, the stricter one, the stricter one, the beyond a reasonable doubt is what should be the standard.
And think about it, this case was decided in the 70s, so it probably went up, to the Supreme Court like, late 60s or so, 69, 68. So before then, juveniles that were charged with crimes, the standard that we have to follow, it wasn't there. So states could do whatever. Exactly. But again, in the name of parents patriae, informal proceedings, where the judge knows best, the best interest of the child, protection, etc. But again, with, Gall, Ken, Reedy Jones, and some of these cases that were decided in this constitutional rights era, is where the Supreme Court started to swing, the other way and afford more adult-like rights to children. And we already know, again, statutorily, we've got that same standard in not only our delinquency part of the statute, but what other case involving children in Massachusetts is the standard beyond a reasonable doubt?
Roberts?
No, what other kind of case? Delinquencies, obviously, we have to follow beyond a reasonable doubt because that's the law of the land, that's Winship. So we can't, and of course we can't go more than that because there isn't any more than that, right? But besides our delinquency cases, what other kind of case does Massachusetts mandate that the reasonable cause, beyond a reasonable doubt standard must apply? Not care and protection. Your CRAs, your old Chins cases, which are not as, the child isn't And that's, again, where we go further, because all Winship says is that they're entitled to proof beyond a reasonable doubt when what, Nicole? They're charged, they're entitled to proof beyond a reasonable doubt
Yeah.
when, according to the court in Winship,
When they're criminal defendants.
yeah, when they're charged, exactly, when they're charged with a violation of criminal law. So we already know that CRA cases that we have in Massachusetts, they're not charged with criminal laws, right? The acts that the children allegedly commit that hold them out to juvenile court jurisdiction under CRA are what we used to call status offenses. They're acts that are not necessarily criminal, but make it hard for the school systems and the families to get along with children and maybe hold them out to potentially violate the law. Being truant, running away, not obeying at home, not obeying in school, in and of themselves are not criminal acts, okay? But, the child who is truant maybe is also likely to end up in criminal trouble as well. And that could be some reason for our state legislature to have written into the statute that not preponderance, not clear and convincing, but beyond a reasonable doubt applies in the CRAs as well. Okay, so that's Winship, and that's all you need to know from Winship. Kent v. U.S. was a little bit earlier, 66, and it was the first case that went to the Supreme Court on what standards should apply when you're transferring a child to adult court. Who wants to talk about Kent?
Can I?
Stephanie?
go a little?
I'm sorry, what?
I'm going to talk a little bit about, it's a case where 14-year-old broke into someone's house and.
Stephanie, can you speak up just a little bit?
I'm sorry. He was at the time, Kent was, he came to juvenile court in the District of Columbia, and at that time he was 14. He was apprehended because of the house break-ins. He actually raped someone, and he was also raped, he robbed. He basically was apprehended, but I think the issue was that his mother wasn't made aware of it until 2 days later, or the following day. This happened September 5th, and then they held him, they detained him, sort of like a detaining center during the arraignment.
What court tried him? And under what process?
It was the juvenile court.
You sure?
No.
What did the juvenile court do after it got the case? And you said it was a quite serious case, he was over 14, what did the juvenile court do?
My screen goes, but as I recall, they basically argued that they had to detain him, but I don't remember, the mother was upset, and I guess retained a lawyer to fight about the fact that she didn't have her son. No one was informing her.
You said the case was serious.
Yes, it was.
And he was over 14, I'm saying it again.
Oh.
And did the juvenile court want the case?
No, they didn't, that's why they didn't.
Right. The juvenile court kicks it over,
Right.
but does it in what kind of process that the Supreme Court and obviously the appellants had trouble with? Amanda?
The waiver of jurisdiction,
Yeah, what does that mean?
is it like where they just assigned it, like this is not an issue for juvenile court, we're gonna transfer it
Exactly,
to the.
right, and remember I had talked to you guys about our old transfer hearings in Massachusetts, it was the same sort of thing. The juvenile courts back then really didn't have any kind of process by which a decision could be made. Well, the decision was still made. The juvenile court judge just said, this case isn't being tried here. I'm waiving jurisdiction. He needs to be tried as an adult, right? What were, or should have been, what were the, juveniles' arguments relative to that we need to have some process because it violates my rights. So, go ahead.
So, I think the issue, ask that question again?
So think back to Galt.
Yeah.
What's he entitled to before juvenile court makes that determination that he needs to be tried as an adult?
So like right to notice?
More than, well,
Right to
Counsel.
counsel.
Fundamental fairness.
fundamental fairness is the objective standard, but you need to have a hearing before the decision is made. And that was the reason, again, for the old, transfer hearings. Before you make the decision, yeah, he's over 14, he allegedly committed rape, I don't wanna try him here. Basically, that's what what they were doing. So the Supreme Court said, and what were the reasons for Supreme Court saying this? You need to have this whole procedure where you're gonna have a hearing, and then if the judges need to consider certain factors. What are some of those factors? Spout out some of them, Mike.
The seriousness of the alleged offense to the community.
Seriousness of the offense.
Whether the protection of the community requires waiver. Whether the alleged offense was committed in an aggressive, violent, premeditated, or willful
Okay, so
manner.
the first one had to do with the tie to the community, the public safety. And the reason why I'm bringing this point out is even though we've abolished transfer hearings in Massachusetts, remember when I talked about the sentencing hearings in the youthful offender cases, public safety is the overriding factor. Go ahead, Mike.
You want me to read that one again?
No, that's okay.
Whether the alleged offense was against persons or against property, greater weight.
So now, I'm sorry, so those two, now we're looking at the offense itself. How horrible is what, the juvenile has done.
The prospective merit of the complaint, whether there is evidence upon which a grand jury may be expected to return an indictment.
Okay, let me just say something about this for a moment as well. So when we did have the transfer hearings, we first had a probable cause hearing. In the probable cause hearing, very low threshold, is it probable that a crime is committed? It's probable that it was this defendant that has committed the offense. So very low, but still the court is looking at as you recited from the opinion, the merit of, the evidence that the grand jury got, or would get if there hadn't been an indictment yet. Okay.
The desirability of trial and disposition of the entire offense in one court when the juvenile's associates in the alleged offense are adults who will be charged with a crime in the U.S. District Court.
So put him with all the others.
The sophistication and maturity of the juvenile is determined by consideration of his home, environmental situation, emotional attitude, and pattern of living.
So this factor is huge, and it's what we talk about when we look at these other cases, the Robert v. Simmons, Green v. Florida, Miller v. Alabama, et cetera, the brain science, looking at the juvenile's culpability at the time of the crime, looking at the juvenile's age, maturity, mental factors, et cetera. Okay.
The record and previous history of the juvenile, including previous contacts with the Youth Aid Division, other law enforcement agencies, juvenile courts.
Exactly, so is this his first offense? Does he have a prior record? What does probation have on him, et cetera?
And the prospects for adequate protection of the public and the likelihood of reasonable rehabilitation of the juvenile.
Yeah, is he, is the aim, if we keep him here in the juvenile system and where the aim is rehabilitation, is that likely to be accomplished in the juvenile system? So, this is all, it seems to us very reasonable, but it wasn't done, and that's it. That's all you have to know about Kent, that before you do bind a juvenile over for treatment in the adult court, you have to be, you know, have to have the hearing beforehand, and you have to have a statement of reasons, and adequate reasons for trying the juvenile and sentencing the juvenile in adult court. And then the same guidelines apply in our mass juvenile system as well. Yes, we do have trial first in the youthful offender proceedings, but even with that, the judge considers in the sentencing hearing all of these factors as well. Mike?
Well, just a question on this case. So, from what I remember when I was reading this case, the attorney had objected to not receiving certain evidence, the social services report that the judge had and whatnot. And then in the judge's order, he said, after full investigation, that he felt it was appropriate for transfer. If he had listed out what he, do you think this would have been different, where they would have said,
Yeah.
well, he listed out, you know, specific findings of fact of this is what he considered?
Right.
Because he did say, you know, after full investigation, but there was no hearing
There
per
was no
se.
hearing,
So
exactly.
I just didn't know if it was
There was no, like,
more an
you
issue
said in
of
quotes,
there was no hearing, or
in
that
which
there
the
was no
parties got
specific
together,
findings
and
in
there's
the
a
opinion.
Exactly. And
So
there's a
which do you think was the greater issue, that there was no actual hearing, or that there was no specific findings in the opinion to support that the judge considered all this stuff?
Well, both, because you have the hearing, and then you have the findings and the ruling, you know, the decision, you know, and the backup for that decision after having, you know, affording the juvenile a chance, basically, to present his or her evidence. You know, because it's not just the state, can the juvenile present evidence that he or she should stay in the juvenile system, that he or she is eligible and likely to be, you know, quote, saved by the juvenile system. Whereas the whole reason for binding people over, like they did in the past, was that sort of that the juvenile system, for whatever reason, has failed for this particular child. That the juvenile system could not help or protect or rehabilitate this child. And it's based on a number of factors just like this. The seriousness of the offense, you know, his record, his age and maturity, you know, whether he has any mental illness as well, you know, all of these factors, the protection of the public. Amanda?
The home life too.
The home life,
Some of
absolutely.
these cases you read and you would think that CMP should have been filed years ago and it could have
Yeah.
maybe prevented.
Exactly, exactly. Okay, Breed Jones was decided in '75, another due process right guaranteed now by the Supreme Court. Let's see, who hasn't gone, Joe?
Well,
Breed Jones? Did you already?
yeah, I already did, but I'll go.
Huh?
Okay.
Short term
Yeah,
memory?
double jeopardy. Whether, the issue here is whether the prosecution of juvenile as an adult after juvenile court proceedings, which have resulted in a finding that the juvenile had violated a criminal statute, and a subsequent finding that he was unfit for treatment as a juvenile, violated the 5th and 14th Amendments to the Constitution. Here, a petition was filed alleging that the respondent, then 17, while armed with a deadly weapon, had committed acts which, if committed by an adult, would have constitute robbery. A detention hearing was held, and the respondent was ordered detained pending a hearing on the petition, and juvenile court then held a fitness hearing and declared the respondent unfit for treatment as a juvenile, and ordered that he be prosecuted as an adult. So the question here is whether, you know, the respondent was put into jeopardy here because, or it was twice put into jeopardy because he had already.
Yeah, he had a trial in
He had a trial
juvenile
as a
court.
juvenile.
They said, well, wait a minute, you know, the juvenile court can't help him. Let's try him again now in Superior Court. So he didn't have a transfer hearing, he had an actual trial. And remember, we read one other case on double jeopardy that dealt with a juvenile having done something in school. Do you remember that case?
Yeah.
In school, and then being tried criminally as well, where he argued double jeopardy. Did double jeopardy apply? It was a mass case, I believe it was Commonwealth v. Stone, one of the earlier cases. Do you remember looking at that when we talked about student violence, the Milo case, etc.? He was disciplined in school. Do you remember that?
Yeah, but
And
that's
then
not an
he was-
adversarial criminal proceeding, so.
Yes, so that was one other case that dealt with an argument on double jeopardy that didn't win.
So I would say, if you look at the facts here and what applies here, that.
Exactly,
that's
because
very
what's
close.
double jeopardy? Double jeopardy has to do with trial,
Right.
which being, exposed to loss of liberty in a criminal trial, and he was exposed twice. And so the Supreme Court said, no, you can't do that with kids as well. Can't do that with adults, can't do it with kids either. And then we jump ahead to 2005 with Roper v. Simmons, which actually followed from an earlier case that I didn't give you because it dealt with execution of the mentally retarded, Stanford v. Kentucky. And the court in Simmons sort of follows from that case. Laura, did you have your hand up?
Yeah.
Oh, you did, I thought you couldn't see.
Well, I can see a little.
Okay.
I can't see you. So the issue in this case was whether it's okay to execute a juvenile offender who was older than 15 but younger than 18 when he committed a capital crime. This kid was 17 and he committed murder. There was no question that he was the instigator. He had told people ahead of time.
What did he do? It was really
It was
horrific
so
murder.
gruesome. He went to a woman's house. Her husband was away on a business trip. He duct taped her mouth and her eyes
Mhm.
and put her in her van, drove her to a bridge, and before he threw her over the bridge, he duct taped her entire head and put wire around her feet and arms so she drowned.
Yeah.
So really cold-blooded. And he bragged about it afterwards.
Mhm.
So they not only, and he did a number of other things, burglary and kidnapping and everything. And so they found him guilty and they said that he'd be executed. And then the case went through how the Eighth Amendment says that excessive bail shall not be required, nor excessive fines imposed, nor cruel and unusual punishment inflicted. And then it then went on to say, when you have a juvenile, the reason that that's relevant is because first, as any parent knows in the scientific and sociological studies, know the lack of maturity and undeveloped sense of responsibility are found in youth. Secondly, that juveniles are more vulnerable or susceptible to negative influences and outside pressures. And third, that the character of a juvenile is not as well formed as that of an adult. And for those reasons, they said that, they then went on to say there are two distinct social purposes served by the death penalty. One is retribution and one's deterrence. And they ended up saying that the differences between juveniles and adult offenders are too marked and well understood to risk allowing a youthful person to receive the death penalty despite insufficient culpability.
So let's go back to the first difference that you reiterated from the court's rationale, the lack of maturity, and how that relates, if you could talk about it at all, to the scientific and sociological studies that have been done on children. Because as you remarked, the act itself was horrific. So we're talking here about culpability, right? Culpability for the crime, at the time it's committed.
Right.
Not to be confused with competence, and we haven't talked about that at all. What is competence to stand trial? What's the difference between competence and culpability? If you can, Laura. right now, we're talking about, all these cases are talking about culpability. What's competence to stand trial? Because that could be an argument for a juvenile as well. Jonathan?
It's more like your ability to recollect, perceive, and communicate. Or something.
In what way? Keep going with that. Who are you communicating with? And perceiving and understanding?
Communicate with, I don't know, with anyone. Communicate with the attorney if you're a witness.
Your lawyer, absolutely. Your lawyer, do you understand the legal proceedings? Are you competent to stand trial? Goes to the present. You right now, the kid, right? Do you understand all of this? Can you go through a trial? Do you understand the legal ramifications? Do you know what a jury trial even means? Can you waive a jury trial? Whereas culpability goes to the past, at the time of the offense. Right? Did you have the capacity? Did you have the capability? Did you have the maturity? And it goes to, you know, the age, some general differences between children and adults. The general differences meaning, you know, the differences the juvenile court already knew about way back when, right? As well as the scientific discoveries. What scientific, you know, we keep talking about the science. What specifically did scientists really find out about the teenage brain? Amanda?
It's actually not fully developed until it reached age 25, and the specific areas which are not developed include the areas in which they could perceive something, you know, plan it and actually carry it out.
Yeah, what area?
Prefrontal cortex.
The frontal lobe, and instead they're reaching back into the limbic, the amygdala, the primal, you know,
Acting on impulse.
brain acting on impulse, etc. And actually has been seen in, you know about MRIs, this is fMRIs, that actually study and see the brain. Stephanie, do you have that?
There's also studies about how that would be related to a regular brain and regular function of a teenager. But when children have received trauma, such as
Yes, add to that not only the child who, for all other purposes, seems okay, but the child who's traumatized.
Right, it multiplies the effect and the damage on the prefrontal cortex, and that
Mhm.
the person lacks, I think in reality you can see it to be true, because if you see a kid who's really been abused, they're affect and they're remorseful, they're normal behaviors of when you're supposed to feel sad or when you're supposed to feel happy, it's not always there. And the chances of recovery is they're still working on the ability to learn more of how soon a person can recover from that.
To learn more.
To learn more about how soon a person could recover, like a child who is a teenager. Can they turn it around? And because the fact that the brain is not fully developed, there's reason to believe that it can be a turnaround, as opposed to someone who is well into adulthood. The chances of that being reversed is slimmer, because there is permanent damage to the brain based on the trauma.
And on the other hand, with early intervention, et cetera, there's a possibility for rehabilitation,
Right.
and for, you know, because the child's brain hasn't become
Right.
fully developed.
It's like you have to retrain it to
Exactly.
have what it should have had in the beginning. And also there's PET scans and MRIs that you could see the differences between a regular normally
That's
developed
right.
brain as opposed to someone who has been through different trauma. Just to compare.
Laura, did you finish? I sort of interrupted you.
Yeah.
Okay.
Well, for those reasons.
So, yeah,
they-
if you had to list, say, you know, okay, if you were telling somebody about Robert v. Simmons, you know, layperson or whatever, say, you know, that was when the Supreme Court held the death penalty is unconstitutional for juveniles. And the person says, well, oh, really? Well, why? You know, if you had a list like a bunch of reasons,
Well, I would start off with, because the brains are undeveloped, there's the opportunity for them
Okay,
to grow
right.
and rehabilitate.
Okay, science is one reason.
Yeah.
What's another reason?
Well, I don't know if this is science or maybe it is that they're reckless. They said they're adolescents are statistically overrepresented for reckless behavior. So, in the same set of circumstances.
How's that different from the overall sort of science umbrella?
That's why I said I didn't know. if
Yeah,
that's-
I just want you
Okay.
guys to sort of think of like the overall, these were the 3 or 4 categories of the reasons why the death penalty and ultimately, like the parole as well, violates juvenile rights. So one is science. Jim?
I think it would fall under science, but I'd say diminished culpability.
Yes, culpability, science, exactly. Well, yeah.
Was one of them the whole thing of, how long their life is, like from being, like a 14-year-old committing a crime compared to like a 7-year-old committing a crime, that the length of that life sentence or,
And that was the rationale looked at not only for that. Are you talking about life sentences now or?
Yeah.
Okay. Joe?
It's not as an effective deterrent for children because they don't understand the gravity of the situation.
Yeah, deterrence was, that was the big thing that proponents always bring up. And it's always brought up in any kind of mandatory crime. Amanda?
Wouldn't it be violation of the Eighth Amendment, cruel and unusual punishments, giving them the most severe punishment?
Giving them, so how is it a violation of the Eighth Amendment?
Because it would be like a cruel and unusual punishment, death or hanging. If being at such a young age, what I'm saying to them would be like a cruel and unusual punishment.
Okay. What else besides the federal, go ahead, Jim?
As I said, I believe that the court held that the death penalty in and of itself is disproportionate to the juvenile versus
The proportionality argument, okay, yep. Joe?
Well, since they're not entrusted with responsibilities of adults, they shouldn't be held to the same standard as adults. I mean, they don't vote, they don't do other, or they're not allowed to do other things that adults are allowed to do. So therefore, they shouldn't be held to the same standard.
Okay. John?
Wasn't national consensus one of them?
Yes, absolutely. And besides national, there's national consensus, there's also international, right? Looking at the Treaty on the Rights of the Child, et cetera. What are they doing all over the world? All over the world, they're not executing kids. At the time, I think it was just U.S. and Somalia, if I remember. Everybody else had ratified.
Or lifetime sentence, or life without parole sentence.
Yeah. Hold that thought, because we're going to discuss life without parole next. Oh, we can get to it now. Let's do Graham v. Florida, and then following from that, even though the cases, I gave everybody Miller. You guys don't have the the new Massachusetts cases, because they were decided in September. Okay. Who wants to talk about Graham v. Florida? Jim?
The facts in this case, the defendant attempted to rob a restaurant with several other individuals, and the manager was assaulted during that attempt. The defendant was charged with attempted robbery. He was on probation at the time. As a result, he was sentenced to life without possibility of parole. He was brought up to the U.S. Supreme Court. The Supreme Court held that the state is not required to guarantee eventual freedom to a juvenile offender committed of a non-homicide crime, but it must give the defendant some meaningful opportunity to obtain release based upon a demonstrated maturity and rehabilitation. And the court found that a life sentence is a harsher sentence for juveniles in addition to the immaturity of the juvenile because of his age. A life sentence is by definition a harsher sentence.
Yeah, and I mean, this case, it was decided in 2010, and obviously Miller followed after that, but it was huge at the time. Because, that whole national consensus, international consensus, the science, the proportionality had been advocated, for a long time, by defense attorneys, by scientists, and finally the Supreme Court started to recognize the whole life without parole argument as well, following from the death penalty argument. So that was Graham v. Florida, and then 2 years after that, we had Miller v. Alabama. Who wants to talk about Miller v. Alabama? John?
Sure. There's a couple things that happened here. A kid named Jackson was 14 years old, decided to rob a video store.
Yeah, so you talk, did I give you guys both cases?
No, you didn't, but
Case?
Miller
I think I only
was
gave you Miller. It doesn't matter, Jackson was the companion case.
Okay.
Correct?
So Miller was a friend of,
You can just recite the facts really quick, because they really don't matter for purposes of our discussion, right?
all right.
All we know, go ahead.
Miller basically struck Cannon while they were getting drunk and high, and told him, "I am God, I'm going to take your life," and delivered one more blow.
Set him on fire and he died,
Yeah.
okay.
Okay, so the whole point of this case is whether the juvenile is afforded a separate sentencing hearing for.
No, before you jump to that, right?
Mhm.
Why did on what basis did the defendants appeal to the Supreme Court? What was their argument? And think in terms of the arguments we just heard in Roper.
That life without parole is overly harsh.
Yeah, well, it was more than that. Not just
Violation of the Eighth Amendment.
Exactly. So they made the same arguments, right?
Right.
That were made in Roper. Yes. So they wanted more. The Supreme Court didn't give them as much. But the argument was that life without parole violates kids' rights because of all these reasons that we just said, right? Just now when we went around the room, all of those reasons that you guys just listed are the same reasons for an argument that life without parole violates juveniles' rights. But the Supreme Court didn't go that far. Jonathan, you want to pick up? But the Supreme Court didn't go that far and ruled totally in the juvenile's favor.
Right. Pretty much.
So what's the actual holding
That,
from Miller, if you had to put in a sentence?
that, life without parole is.
Put an adjective in front of life without parole and you'd get it.
Oh, mandatory life without parole?
Yeah, keep going, so.
Oh, I thought. Oh,
Go
no,
ahead.
that's it. Okay, yeah. Mandatory life without parole.
Violates.
Violates the Eighth Amendment of the Constitution.
That's right. Mandatory life without parole. So you can, under the federal standard, you can still have life without parole as long as you do what? And that's what John was saying at the beginning. Yeah. So what does that mean? Have a hearing. Because I know you've been writing about it.
I call it like Miller hearing to see, it's like a sentencing hearing before it happens. You have that last hearing to see what mitigating circumstances they can rule on regarding that individual in particular.
What guidance does the Supreme Court give us, Laura, in Miller? Jim?
I think the court held that the state is not required to guarantee eventual freedom.
I'm sorry? The court held
The court is held that the state is not required to guarantee eventual freedom, but must provide some meaningful opportunity to obtain release based on demonstrated maturity and rehabilitation.
Say it again. Some
Meaningful opportunity to obtain release based upon demonstrated maturity and rehabilitation.
So what does that mean? In light of our talk that we just had now about culpability, and a whole court should consider all of this stuff.
Well,
Other-
as they mature and grow, I mean, they can change as people and they should be.
No,
allowed.
all that is true. That's a given. But think of, so you have the Supreme Court, now speaking again, the law of the land, this is what you guys meaning all of you states, have to follow. And yet, you have this generalized language, and Jim read from some of it, that basically says that, oh, okay, there's some kind of, okay, mandatory life without parole. You can't just do, for example, what Massachusetts was doing at the time, was that because we had life without parole for defendants convicted of murder one, and because the juvenile court didn't have jurisdiction of juveniles charged with murder, that meant when at the conclusion of the trial, when Commonwealth had proved murder one beyond a reasonable doubt, juvenile got life. That's mandatory life without parole. Okay? So Supreme Court says you can't do that without a hearing to consider, right, the juvenile's circumstances, character, culpability, maturity, et cetera, et cetera, et cetera. And what I'm getting at is this, leaves it up to the states to figure out
What they want to do individually.
how to do it. Says you have to do it. You have to do
Somehow,
it.
some way.
Yeah, before you can give life without parole, you have to consider the juvenile somehow in coming up with that sentence. So what does Massachusetts then do? And we have a few minutes, but we'll take this up again sort of as an introduction to the Mass cases. And I'll ask for those people that are a little bit familiar with what Massachusetts did to speak up. Jonathan.
SJC held that life without parole, whether mandatory or discretionary, is unconstitutional.
According to
Which cases?
according to which constitution?
Oh, the Massachusetts.
Exactly. So violates our Constitution, Article 26 of our Constitution. So there's no life without parole, according to Massachusetts. Two companion cases that were decided are actually on Christmas Eve. The first is Diachenko, D-I-A-T-C-H-E-N-K-O, and the other is Brown. Now, Diachenko was actually an older case. So think of it this way. Miller v. Alabama comes down in 2012. Well, you now have adults, jailed somewhere doing a life sentence. And what do you suppose happens? Defense attorneys all over the place are filing appeals. Well, Diachenko had been sentenced back in the 80s. He's in his 30s.
Could you spell that one more time?
D-I-A-T-C-H-E-N-K-O.
Thank you.
And so there was one question: what do you do with these people that had exhausted all of their appeals? Because he went all the way to the SJC at that time, arguing that life without parole violated the Mass Constitution, and he lost. So the first question was that going to be retroactive? SJC ends up, and you can read the opinion if you want, holding that yes, so Miller is retroactive to Diachenko and the other defendants like Diachenko. But then Diachenko was also arguing that, well, wait a second, Miller said I can get a sentencing hearing. I want a sentencing hearing now. He was doing life without parole. SJC holds that, well, no, you don't need a sentencing hearing. What we're going to give you is what you would get for a murder two defendants, life with parole, with the eligibility for parole after 15 years. And so and then Brown was the newer case, kid who just got tried and again is appealing, saying, wait a minute, I need a sentencing hearing too. Brown court holds that, you know what, again, we're going to go with that we have the procedures in place for parole, and that's sort of good enough, and we're not going to go further than that. And so that's the state of the law in Massachusetts today. So the good news is there's no life without parole, period, for juveniles that get tried in adult, because remember, they're still getting tried in adult court because the legislature has not changed the remember the youthful offender statute that provides that juvenile court doesn't have jurisdiction of juveniles charged with murder. So that applies to murder 1 and murder 2, right? And so because of that, you have juveniles charged with murder 2. They're going to do life, but they're going to do life with parole.
But even with the
But-
parole, are they gonna even really?
Exactly, and so these are the arguments that are being made, you know, parole, life with parole, with eligibility. By the way, 15 years, there's also been bills filed to up the period of time to 35 years, I believe. There's just statistics either way as to how many people are actually, you know, granted parole. There's arguments back and forth that this is really the legislature's job. When the Brown case was decided on Christmas Eve, the SJC also, you know, sort of makes mention that the legislature should now be acting. Miller is, you know, now going on, what am I saying, going on almost 3 years. So that's where we are at right now with the feds as well as the state of Massachusetts on life with and without parole. So other states, again, can do what they want. Massachusetts has decided that life without parole violates the Mass Constitution. So that means the Commonwealth is not going to be charging for murder 1, but they're going to be charging for murder 2. And again, worst case is life with parole, possibility of parole in 15 years for juveniles. And that's stage control and Brown. So that's it so far for juveniles getting life.
Wonder what's gonna happen years from now, because we saw in Ruba, like, you take away the death penalty, then it's like, you take away the life
Exactly,
without parole.
exactly.
Now you have life with, and.
And if I'll leave you with one final thought. Is it that we're coming full circle in sort of, you know, granting more and more due process rights? Or, I'm sorry, not, well, no, let me start again. Are we going back in time, as the dissent in Galt mentioned, to a place where, you know, kids are going to get, you know, the same sort of trials and punishments as adults? Or are we really just coming back full circle for the reason why the juvenile court started in the first place, protection and rehabilitation of children, and the, you know, scientists sort of really the saviors in this regard, in the sense that these inroads and wins for juveniles have been made largely because of what the, you know, scientific community has found out about children that really the juvenile court, you know, founders already knew way back when. So we'll do the mass cases on Thursday, or at least we'll get started with them.
And then you'll let us know by email on Thursday about Tuesday.
Yeah, by the end of Thursday's class, we'll make that decision.